Good morning. I'm Victor Bolden of the United States District Court for the District of Connecticut. Welcome to this Women in the Law program, sponsored by the New York City Bar Association, with many thanks to Brett Parker, the association's executive director, and his wonderful staff for taking the baton from the Second Circuit Conference Committee and bringing this event to all of you. Originally scheduled to be the subject of this year's Second Circuit Conference in recognition of the centennial of the United States Constitution's 19th Amendment, this event has taken on even greater significance in the wake of the death of Justice Ruth Bader Ginsburg. Perhaps no one in the law did more to create a pathway for women in the law than Justice Ginsburg. And in doing so, she helped men to reorient their life in the law as well. As I turn this program over to our next speaker, I will end where I began, thanking others, specifically the Second Circuit Conference Planning Committee, whose names will appear on the screen. Thank you to the extraordinary administrators, some of the names are listed here, as well as the staff at the Second Circuit, some of whom I've had the good fortune to work with for 2 years. Thank you to the various judges of the Second Circuit who considered this program integral, not ancillary, to their work administering justice. Thank you to the outstanding legal scholars, including law school deans, who by finding the time to serve demonstrated the importance of extending their educational mission beyond their students. And thank you to those leading members of the bar, both in private and public practice, who despite the many demands on their time, made this event a priority. I have no doubt that you will all enjoy the work of this legal dream team. Both this event and the legal dream team who brought it to fruition are the handiwork and part of the legacy of our next speaker's recently ended tenure as Chief Judge of the U.S. Court of Appeals for the Second Circuit, Judge Robert Katzman. Judge Katzman, I turn the program over to you.
Thank you, Judge Bolden, and thank you for being such a fabulous conference chair these last 2 years. I will always cherish our partnership and your leadership as we thought about various conference projects. As I thought of my last circuit conference as Second Circuit Chief Judge, the theme that I proposed for consideration of the committee, our wonderful committee, and Judge Bolden, seemed obvious: women in the law. After all, 2020 marked the 100th year of the ratification of the 19th Amendment, enfranchising women, and declaring for the first time that they, like men, cannot be denied the rights and responsibilities of citizenship. The stars seemed aligned. We would be meeting in upstate New York in June, and of course, it was in upstate New York that women reformers gathered to press for a strategy that would lead to women's suffrage. Our Circuit Justice, Ruth Bader Ginsburg, herself a pioneering legal advocate for women's rights, would be an active participant. My successor as Chief Judge, Deborah A. Livingston, like Justice Ginsburg, a highly regarded Columbia law professor, was poised to make history herself, by becoming the first woman Chief Judge of the Second Circuit at the end of the summer. At the program would be exhibits designed by the Second Circuit Library team, including a booklet cataloging all the women judges in the history of the courts of the Second Circuit. By the way, that booklet is available by going to the Second Circuit website, and you can see the Justice for All website and click on and you can find the booklet. But alas, COVID-19 intervened and the conference had to be canceled. And to the rescue, as Judge Bolden so eloquently and elegantly said, came the New York City Bar Association and the extraordinary Brett Parker and his team, who took on the hosting of this planned program of panels of the conference. I'm so grateful to the City Bar, to Brett, to Roger Maldonado, to the incomparable New York City Bar President Sheila Boston for being such a great friend to me, and to our federal judiciary during my tenure as Chief Judge. And I'm grateful to Chief Judge Livingston for her enthusiastic support of this New York City Bar hosted event. Justice Ginsburg thoroughly approved of the conference theme, Women in the Law. Indeed, her life history is so intertwined with the subject of this conference, and she was so delighted that the New York City Bar saved the day. She thought the New York City Bar was the perfect solution to our pandemic problem. I have no doubt that she would have participated if she could have. For both the New York City Bar, the sponsor of the Ruth Bader Ginsburg Lecture, and the Second Circuit Judicial Conference, which she faithfully participated in, always the highlight of our judicial conference, were dear to her. Justice Ginsburg was so many of us our polar star, a stalwart friend for all seasons, who always had others ahead, but always put others ahead of her own convenience. I know she would have participated here no matter what, if she could have. In our grief, let us dedicate this day to her memory, to our beloved Circuit Justice Ruth Bader Ginsburg, mindful that she would ask us to commit to the unfinished work of ensuring justice for all. Thank you.
Good morning, everyone, and happy Friday. As president of the New York City Bar Association, I'm delighted to be with you today, and I'd like to thank the Second Circuit for entrusting us, the City Bar, to host its judicial conference this year. I wish to give a special thanks to Judge Victor Bolden, the conference chair, as well as Judge Robert Katzman for the leadership he's provided over the years as chief judge, and for just being a class act in all that he does. Now, I must tell you that I was very excited when I learned what the theme of today's conference would be. When I became the 69th president of the City Bar, I announced my 6 top priorities for the organization. And one of the 6 is diversity, equity, and inclusion, an initiative and area of concentration which I believe nicely dovetails and includes discussions about women in the law. And notably, I have the honor of being the 5th female president of the New York City Bar and the first woman of color president of the New York City Bar as we celebrate the City Bar's 150th anniversary. And in speaking of history, or may I say her story, I'd be remiss if I did not also mention, like our esteemed judges, that giant of a woman, lawyer, judge, legendary legal visionary, icon, and true trailblazer, Justice Ruth Bader Ginsburg. I'd just like to express that we will truly miss her, as Justice Ginsburg was a beloved member of the New York City Bar Association, and her fondness for us and allegiance was evident by her request that we house and display her official Supreme Court portrait painted by Constance P. Beatty in the meeting hall of our storied City Bar building for the past several years. It was located directly across the hall from the podium where some of us now virtually sit. But that portrait has now been duly returned to the Supreme Court in Washington, D.C. So we will rehang and display our own original City Bar portrait of her in the meeting hall in its stead in New York City as a tribute to her. But we're just so grateful that she honored and entrusted us with a great treasure of hers for the time which was allotted to us. What a blessing it was to have her amongst us, and may she now rest in peace and power. I want to thank everyone in attendance at our virtual conference today, and I'm filled with excitement and anticipation of the presentations on women in the law. So without further ado, let me introduce to you our keynote speaker, Reeva Siegel. Professor Reeva Siegel is the Nicholas Katzenbach Professor at Yale Law School. Professor Siegel's writing draws on legal history to explore questions of law and inequality, and to analyze how courts interact with representative government and popular movements in interpreting the Constitution. Professor Siegel has written on ties between the 19th Amendment and the family, including most recently in a work entitled The Pregnant Citizen from Suffrage to the Present, published in the Georgetown Law Journal 19th Amendment Special Edition this year, which showcases the work of Ruth Bader Ginsburg in the 1970s and 1990s. Another such work of hers is called The 19th Amendment and the Democratization, of the Family in the Yale Law Journal Forum, also published this year, which spans the 1840s to the present. And a third piece called She the People, the 19th Amendment, Sex Equality, Federalism, and the Family, published in the Harvard Law Review in 2002. Professor Siegel's other recent work ranges widely from her Second Amendment piece, currently in progress, entitled When Guns Threaten the Public Sphere, Restoring the Common Law Approach to Public Safety, to other issues like disparate impact issues and the logic of backlash and constitutional adjudication. Her books include most recently Reproductive Rights and Justice Stories, edited with Melissa Murray and Kate Shaw, published last year, and Processes of Constitutional Decision-Making, with Brest, Levinson, Balkin, and Ahmad, published last year in its 7th edition. Professor Siegel is a member of the American Philosophical Society, a fellow of the American Academy of Arts and Sciences, and an honorary fellow of the American Society for Legal History. She serves on the Board of Advisors and the Board of Academic Advisors of the American Constitution Society, and on the General Council of the International Society of Public Law. Very impressive. We are indeed quite fortunate to have her here with us today. I introduce to some, and I present to others, Professor Reeva Siegel.
Thanks so very much. I'd like to extend my thanks to Judge Katzman, Judge Bolden, Judge Furman, the Planning Committee of the Second Circuit Judicial Conference, as well as to Sheila Boston and the New York City Bar for the invitation to speak today and to address the conference as initially planned as well. So the world is convulsed in more ways than one since we first imagined this convening. First part of it, as you've heard, the Second Circuit Judicial Conference marking the 19th Amendment centennial. And inured as many of us are becoming to this steady stream of news these days, and prepared as perhaps we should have been, when the word of Ginsburg's passing last Friday hit me, I was nonetheless shocked, although even as we should have been prepared. And yet I have not, and none of us yet, have fully taken in the significance of the loss that it represents. The dimming of what I believe, and we all know to be, an utterly luminous thought force in the nation's life and the life of this circuit in ways that are just too many to count. The arc of Ginsburg's life so fundamentally transformed the status of women at law that it demanded recognition and actually led me to change the way in which I was going to address us this morning. And so my talk this morning, instead of addressing the 19th Amendment centennial, speaks about these themes through the prism of Justice Ginsburg's work. I'm omitting all I might say about RBG in my own life, which could fill the text, and instead will turn with all due attention to her as text and reach, by the end of my remarks, the 19th Amendment in closing. I ask no favor for my sex. All I ask of our brethren is that they take their feet off our necks. Many of you will recognize this defiant mantra as a favorite of Ginsburg's, who from early on quoted abolitionist Quaker minister Sarah Grimke's 1837 letters on the equality of the sexes. Ginsburg was a fierce egalitarian. But my question is for us, an egalitarian of what kind? Many understood this mantra, the proud ask no favor for my sex, as a demand for same treatment. In editorials this week, we've been told that in the 1970s, the young Ginsburg, quote, convinced the entire nation through her arguments in the Supreme Court to adopt a view of gender equality where equal means the same, no special accommodations for either gender, close quote. A loving tribute to Ginsburg in the New York Times, published by two former clerks and dear friends of mine, emphasized that, quote, for Justice Ginsburg, equality did not mean special. she would say pedestal treatment for women, equality meant the same treatment for women and men, close quote. The authors reminded us that RBG, quote, often used male instead of female plaintiffs to show sex discrimination prevents everyone from realizing their full potential, close quote. Another quote, her aim was to break down the stereotypical view of men's roles and women's roles, close quote. She rejected the term women's rights and instead, quote, equal protection demanded that both women and men be given, in RBG's signature phrase, full citizenship stature, equal opportunity to aspire, achieve, participate in, and contribute to society. In what follows today, I want to pay tribute to Justice Ginsburg as a fierce egalitarian, one who sought equality for women and for men, yet who did not believe that equality always meant, quote, the same treatment for women and for men, close quote. Her opinion for the court in the United States against Virginia, one of the richest and most theoretically developed accounts of equal protection in the United States reports, prohibits women's exclusion from Virginia's premier military academy. Yet the opinion nowhere emphasizes sameness. I actually searched the text. Justice Ginsburg might simply have banned sex-based state action or emphasized the importance of treating the similarly situated, treating similarly those who are similarly situated. But her famous opinion in Virginia does not reason from these premises. It offers a full-throated affirmation of equal citizenship in terms that recognize and even celebrate difference. So how could an egalitarian who so often quoted Sarah Grimke's mantra, I ask no favor for my sex, who is associated with breaking so many barriers to women's participation, celebrate equality and difference? More concretely, how did Justice Ginsburg manage to write an opinion for the court that required VMI to admit women without banning single-sex education? Consider Virginia's Note 7, which distinguishes and seemingly allows single-sex education that, quote, dissipates rather than perpetuates traditional gender classifications. How did Justice Ginsburg write an opinion for the court that required VMI to admit women, yet that allowed, quote, alterations necessary to afford members of each sex privacy from the other sex in living arrangements, close quote? See Note 19. Justice Ginsburg's opinion for the sixth justice majority enforces equality or equal protection and difference, or as the majority so memorably expresses the principle animating its reasoning, quote, inherent differences between men and women we've come to appreciate remain cause for celebration, but not for denigration of the members of either sex or for artificial constraints on an individual's opportunity, close quote. But given the long and sorry history of laws justifying women's exclusion in the language of inherent differences, how would Justice Ginsburg, of all people, entrust judges, with the business of deciding which differences remain cause for celebration and which differences are a source of denigration and of artificial constraints on an individual's opportunity? The answer Justice Ginsburg offers in Virginia ties the equal protection inquiry to history, not to the history of original understanding, but to history of a different kind. I quote one of the decision's most famous passages. Today's skeptical scrutiny of official action denying rights or opportunities based on sex responds to volumes of history. You must recognize this passage. As the plurality of this court acknowledged a generation ago, our nation has had a long and unfortunate history of sex discrimination, she says, citing Frontiero versus Richardson, 1973. Through a century plus 3 decades and more of that history, women did not count among voters composing We the People. Not until 1920 did women gain a constitutional right to the franchise. And for a half century thereafter, it remained the prevailing doctrine that government, both federal and state, could withhold from women opportunities accorded men so long as any basis in reason could be conceived of for the discrimination, she says, citing Gozart. History, a history of wrongful sex discriminatory state action justifies heightened scrutiny, and history, a history of wrongful sex discriminatory state action guides heightened scrutiny. History is a warrant and history is a guide. In this famous passage of Virginia, history is invoked as negative precedent, just as slavery and segregation are negative precedents in equal protection law, past wrongs against which the nation defines itself. In this passage of Virginia, as I've written at some length that I will develop in closing in these remarks, we see an opening to synthetic interpretation of the 14th and 19th Amendments. After telling us that skeptical scrutiny responds to volumes of history, Virginia puts the 14th and 19th Amendments in relationship to one another. Observing that from the founding through Reconstruction and after, quote, women did not count among the voters composing We the People, that women were not even given the vote until 1920, and that women's systematic exclusion persisted for half a century thereafter. Virginia invokes the logic of women's disenfranchisement and its continuing legacy after the 19th Amendment's ratification to justify and guide the enforcement of equal protection in cases of sex discrimination. So what difference does this make in applying heightened scrutiny? While most commentators on BMI focus on Justice Ginsburg's instruction that the reviewing court must determine whether the proffered justification is exceedingly persuasive, Virginia has much more to say than this command. Virginia provides the court a new guide to applying the standard of review that was first forged in the 70s cases that Ginsburg herself once litigated. In Virginia, Justice Ginsburg goes on and offers this historically informed guide, as I've suggested. Unlike the 70s cases that imagine sex equality ending with the identification of physical differences between the sexes, think of Geduldig versus Aiello, the pregnancy case, or Michael M., the statutory rape case, Virginia confidently recognizes sex equality while acknowledging physical and social differences between the sexes. That's because Virginia reasons about equality not as sameness, but in terms of social status and social roles. In this critical passage, Virginia asks courts enforcing the equal protection guarantee to examine a law that classifies by sex and determine the law's purpose and effect, considered in historical perspective, to determine how it affects women's social status and social roles. She says, inherent differences between men and women we've come to appreciate remain cause for celebration, but not for denigration of the members of either sex or for artificial constraints on opportunity. Sex classifications may be used to compensate women for particular economic disabilities they've suffered, citing Califano, her case, to promote equal employment opportunities, see Cal-Fed versus Guerra, I'll return to advance the full development of the talent and capacities of our nation's people. But such classifications may not be used, as they once were, see Gozart, to create or perpetuate the legal, social, and economic inferiority of women. More happens in this brief passage than I can discuss in the time allotted. I'm going to unpack one underappreciated passage in it that I've discussed in an article recently published in Georgetown Law Journal entitled "The Pregnant Citizen from Suffrage to the Present." In the passage I've just quoted, the Virginia court plainly embraces this historically informed social roles or anti-subordination approach to sex classifications. They can be used to compensate women for particular economic disabilities they've suffered, a passage that seems pretty plainly to sanction affirmative action. But classifications may not be used, as they once were, to create or perpetuate the legal, social, economic inferiority of women. Internal to this passage, we can see the court reason about pregnancy in this social roles-based fashion. The Virginia court limits the reach of its 1974 pregnancy case, Geduldig versus Aiello, by invoking its 1987 decision, Cal-Fed, a Title VII case about a state law mandating the reasonable accommodation of pregnancy in the workplace. Virginia cites the law in Cal-Fed as an example of a sex classification that promotes equal employment opportunity. Where Geduldig was not confident that a law that classified on the basis of pregnancy classified on the basis of sex, Virginia treats the pregnancy accommodation law at issue in Cal-Fed as a sex classification subject to heightened equal protection scrutiny. Moreover, Virginia treats the California law regulating pregnancy as a permissible sex-based classification because the law promotes equal employment opportunity. In CalFed, Justice Marshall upheld California's statute mandating the reasonable accommodation of pregnant employees under the PDA, the Pregnancy Discrimination Act, after determining that the law mandating accommodation was narrowly drawn to cover pregnancy and the period of actual physical disability only, and did not reflect stereotypical notions about pregnant workers associated with protective labor legislation of the early 20th century. The accommodation mandate in CalFed enables women to retain employment. It did not push women out of the labor force or push them into economic dependency on another wage earner, their husband, or the state. The pregnancy accommodation mandate in CalFed does not enforce breadwinner caregiver stereotypes, it disentrenches them. Justice Marshall's analysis in CalFed exemplifies the kind of historically informed social roles or anti-subordination analysis that Virginia itself mandates for judges to determine whether state action regulating pregnancy violates equal protection. I promised that I would reach the 19th Amendment through the lens of Virginia, which I will now do in closing. So, as we've seen, Virginia offers a natural portal for what we could call a synthetic interpretation, a joint interpretation of the 14th and 19th Amendments together. As I've shown, the decision directly appeals to women's disenfranchisement and to the 19th Amendment's delayed ratification and enforcement as justification and as a guide for heightened scrutiny. This is a perfect juncture to incorporate, as I've explored elsewhere at greater length, the pre and post ratification of the 19th Amendment. Women's quest for the vote spans at least a century and several constitutional amendments. The claims began in the anti-slavery movement in the 1840s, became part of the arguments for the 14th Amendment, then the 15th Amendment. And when the demand for women's suffrage is shut out of Reconstruction, spent several decades more in the wilderness of state constitutionalism before resuming life in the quest for the 19th Amendment. Even after the 19th Amendment's ratification, women of color are still seeking the right to vote, at least until the passage of the 1965 Voting Rights Act, if it's not, to be said, continuing into our present day. Those seeking women's right to vote under the 14th Amendment may have been shut out of Reconstruction, but it was only because they were ahead of their time. In fact, the abolitionist suffragists were pioneers of our modern constitutional order, where the founders insisted that women were virtually represented in the state through their husbands or fathers. Suffragists insisted on direct representation for women. They combined the individualism of the revolutionary constitutional tradition with the radical egalitarianism of the anti-slavery constitutional tradition to propose a 14th Amendment recognizing universal suffrage, a new understanding of the Republic in which all adult members of the household would be equally and directly represented in the state. This egalitarian understanding of the constitutional community underwrote the movement's claim that the 14th Amendment enfranchised women. This universalist vision of the 14th Amendment was not embraced until the era of Brown and the Voting Rights Act in 1965. Indeed, we could say it's still under works or under construction today. The decision to include women as voting members of the constitutional order affected all aspects of the Constitution, and the 19th Amendment can be interpreted synthetically with all of them. It need not be interpreted as a freestanding piece of constitutional text. As I've shown, United States against Virginia, the central equal protection sex discrimination case, offers itself as a natural portal for incorporating the sex equality principle of the 19th Amendment into 14th Amendment analysis, and with that principle, the public memory of suffrage struggle. There are many ways to incorporate the memory of suffrage struggle into our law. We can incorporate women's vote, request for the vote, as negative precedent, as a record of past wrongs that the nation strives to remedy and against which the nation defines itself. And we can incorporate women's quest for the vote as positive precedent, identifying constitution makers who model constitutional virtues and an understanding of our constitutional commitments we want subsequent generations to emulate. The long quest for suffrage features audacious dreamers who dare to claim new, more egalitarian forms of citizenship, family, and constitutional community that we are still struggling to realize today. Whether or not these constitutional architects of our present could vote in their own day, we can surely recognize and honor them in our own. It is time to break the vestiges of virtual representation in the ways that we interpret the Constitution, where we still reason about the founding and the framing and many other questions as if only men made the Constitution. It is time that we threw off the final vestiges of virtual representation in our own thinking and recovered the voices of these Constitution makers whose only fault was to be visionaries, like RBG, so far ahead of their own times that their peers were not yet ready to listen to them. But we can listen to them, the generations and generations of Americans who were not given a vote or authority to craft law in their own day, had views about what a constitutional democracy needs to be. These views are worthy of recovery. Importantly, as I show in a recent article entitled "The 19th Amendment and the Democratization of the Family," suffragists who challenged virtual representation, male household representation, sought the vote to transform the family. They saw the household as a critical site of democratic citizenship for those who perform care work and for those who receive it. They located voluntary motherhood and the value of care work at the core, not the periphery of our constitutional order. A message all the more critical in this time of profound insecurity, when the economy is at a standstill and the line between paid and unpaid labor up for grabs, and the work of social reproduction and its centrality to our survival is now visible for all to see. These themes, in fact, resonate in the work of RBG, who in 1972 briefed pregnancy discrimination as a paradigmatic case of sex discrimination subject to strict scrutiny in Strzok versus Secretary of Defense, and whose earliest cases concerned the uncompensated work of male caregivers such as Charles Moritz in 1972 and Stephen Wiesenfeld in 1975. If we recovered these generations of constitution-making women and the men who supported them, we would have a radically different understanding of our constitutional tradition. We would differently understand the wrongs that should guide an intersectional understanding of equal citizenship law, and differently understand the leaders who might inspire that law, who would give voice to its values, stakes, its principles, and purposes, so that we, the people, would come to recognize it as our law. As the 19th Amendment enters its second century, and we continue to argue over the meaning of our Constitution in courts and in politics, it's time to appeal to a wider cross-section of esteemed Americans, including in our national stories, the voice of the disenfranchised as well as the enfranchised, and the concerns they brought to the democratic reconstruction of America. Imagine how we might understand our Constitution in another generation if we did. Thank you.
Well, thank you, Professor Siegel. Thank you so much for that presentation and just challenging us to adopt a more egalitarian understanding of the treatment of women in the law. Thank you so much. And now at this time, we will take a 5-minute break, but don't go too far away because we have a lot more for you. The Second Circuit's Women in the Law Conference.